Right now, as in right now, there is an active federal lawsuit trying to overturn same sex marriage in America. And the attorney behind it, he's the same lawyer who wrote the Texas abortion ban that took down Roe versus Wade. But here's what no one is talking about. Even if marriage equality survives, and I believe it will, there are financial blind spots in your marriage right now that could cost your partner everything: their home, their savings, even the right to see you in the hospital. Today, I'm giving you the 5-step financial emergency plan that every same sex couple needs to have in place, including one document that takes 20 minutes to set up and could be the most important thing you ever do for your relationship. Let's get into it. In 2015, the Supreme Court ruled for Obergefell versus Hodges, the same sex couples have a constitutional right to marry. We celebrated, we moved on, and most of us never built a financial safety net underneath that right. We treated marriage like it was a magic shield, but it's not. In December, a judge in Waco, Texas, named Diane Hensley, filed a federal lawsuit arguing that the Supreme Court had no authority to legalize same-sex marriage, and that it should be thrown back to the states. Her attorney, Jonathan Mitchell, said the quiet part out loud. He pointed out that the justices who wrote Obergefell have been replaced, and that the court should do to marriage what they did to abortions in Dobbs. Now, am I telling you to panic? No. The Supreme Court declined a similar case just weeks before this one was filed. That we have seen this exact playbook before. A right was established, everybody assumed it was permanent, nobody made a backup plan. And then Dobbs happened. I'm not here to scare you. I'm here to make sure that if anything ever changes, you and your partner are completely protected. So here's the plan. Step 1. And this is the one that keeps me up at night. Imagine your partner is in a serious accident. They're unconscious. You rush to the hospital, and someone at the front desk says, "I'm sorry, we can only share medical information with family." Without a healthcare power of attorney, the hospital can default to your partner's biological family, even if you haven't spoken in years, even if they're hostile to your relationship, even if your partner would never want that. Here's the fix. A healthcare power of attorney, also called an advance medical directive. This is a legal document that names you as the person who makes medical decisions if your partner can't. Federal law requires hospitals to honor it. You can include your pronouns, your chosen name, and your specific wishes for care. And here's the best part. This is the 20-minute document I mentioned. You can set this up through an online legal service today for under $50. There is no excuse not to have this. But that handles medical decisions. What about your money? Step 2. If your partner is incapacitated, can you pay their bills? Can you access their bank account? Can you file their taxes? Without a durable power of attorney for finances, the answer is no. You would need to go to court, petition a judge to appoint you as the legal guardian, and that process can take months and cost thousands of dollars. Meanwhile, the mortgage is due, the car payment is due. Life doesn't stop. The fix is simple. A durable power of attorney for finances authorizes your partner to handle your financial life if you can't. Bank accounts, investment accounts, bills, taxes, all of it. Set it up the same way as your healthcare POA. Same service, same sitting, done. Now, those 2 documents protect you while you're alive. But step 3 is about what happens when you're not. If you die without a will in most states, your assets go to your legal next of kin by default. For married couples, that's usually the spouse, but usually is doing a lot of work in that sentence. In states with hostile legal climates, an estranged family member can contest your estate. And if you're not married, your partner gets nothing. 0. Decades together, and legally, they're a stranger. So here's what you need. First, a will that explicitly names your partner. If you have kids, this is where you nominate a guardian. Without that nomination, a court could give custody to the biological relative over the surviving non-biological parent. That alone should terrify every LGBTQ plus parent watching this. Second, and this is the part that most people miss, You need to audit your beneficiary designations, your retirement accounts, your life insurance, your bank accounts. Those beneficiary forms override your will. So if your ex is still listed on that 401k from 6 years ago, your will doesn't matter. They're getting that money. Quick pro tip: a living trust avoids probate entirely and stays private. Wills become public record. If you have significant assets, talk to an attorney about a trust. It's worth every penny. Okay, those 3 steps protect your relationship legally. But step 4 protects your wealth from a threat most couples have never even heard of. Right now, married same-sex couples have access to something called estate tax portability. In plain English, when one person dies, the surviving spouse can inherit their estate tax exemption. For 2026, that's worth up to $13.99 million per couple. If Obergefell were ever released and your state stopped recognizing your marriage, you could lose access to that protection. We're talking a potential tax hit north of $5 million. Now, is this likely to happen? Probably not. But the fix is easy, so why risk it? Talk to an LGBTQ+ affirming estate planning attorney about locking in protections now, while your marriage is federally recognized. We're talking about proper titling of your joint assets using your annual gift tax exclusion. That's $18,000 per person per year, and potentially setting up a trust. This is the one step worth spending real money on. And the last step? This one's not about documents, it's about freedom. 51% of LGBTQ+ Americans have reconsidered relocation because of hostile state policies. 51%. But here's the part nobody talks about. The average cost of an emergency interstate move is $5,000 to $15,000. First month's rent, security deposit, moving costs, job transition, it adds up fast. So here's what I want you to build: a safety premium fund. This is separate from your regular emergency fund. This is the money that means you will always have options. If you need to move to a state that recognizes your marriage, protects your health care, or keeps your family safe, you can do it next month. Not next year, next month. Target: $10,000 to $15,000 in high-yield savings account, earning 4 to 5% right now. Automate $200 to $500 per month. Treat it like insurance, not optional savings. I call this your freedom fund because that's what it is. It's the money that means nobody, no politician, no court, no hostile law gets to make your decisions for you. Okay, let's bring it home. 5 steps: healthcare power of attorney, financial power of attorney, will and beneficiary audit, estate tax protections, and your safety premium fund. Here's what I need you to do. Not tomorrow, today. Pause this video, screenshot that checklist, and start with step 1, the healthcare power of attorney. 20 minutes, under $50, that's it. I put a free downloadable checklist in the description with every document, where to get it, what it costs, and how long it takes. Grab it. And if you want a full deep dive on the legal documents, I made an entire video walking you through 9 documents that every LGBTQ+ couple needs. Look, marriage is a statement of love. These documents, they are a statement of protection. Make sure you have both. I'll see you in the next one.